Welcome to our exploration of the legal concepts of gifts and leases under the Transfer of Property Act. In this video, we'll break down the essentials of gifting property, the requirements for a valid gift, and the distinctions between gifts and leases. We'll also cover the rights and duties of parties involved, and the circumstances under which these arrangements can be terminated or revoked. Whether you're a law student or just curious about property law, this guide will help you understand the core principles and practical examples that shape these transactions. Section 122 of the Transfer of Property Act defines a gift as the transfer of certain existing movable or immovable property made voluntarily and without consideration, and accepted by or on behalf of the donee. The person making the gift is the donor, and the recipient is the donee. Acceptance is crucial for the validity of the gift, and it must occur during the donor's lifetime while the donor is capable of giving the property. If the donee dies before acceptance, the gift is void. This foundational definition sets the stage for understanding the legal requirements and implications of gifting property. For a gift to be valid, the donee must accept it during the donor's lifetime and while the donor is still capable of giving the property. If the donee passes away before acceptance, the gift is rendered void. This requirement ensures that the transfer is voluntary and mutual, reflecting the intention of both parties. Acceptance can be explicit or implied, but it must be clear and unequivocal. The law emphasizes the importance of acceptance to prevent disputes and clarify the transfer of ownership. Gifts of movable property can be registered or effected by delivery, offering flexibility in how the transfer is completed. However, gifts of immovable property, regardless of value, require registration under Section 17A of the Registration Act. The document must be signed by the donor and attested by two witnesses. This distinction ensures proper documentation and legal recognition of immovable property transfers, safeguarding the interests of both donor and donee. Gift to God Almighty can be made orally, in writing, or registered. This unique provision recognizes the spiritual and religious context of such gifts, allowing flexibility in the method of transfer. Whether the gift is documented or simply declared, the law accommodates the donor's intention to dedicate property for religious purposes, reflecting the diversity of legal and cultural practices. Let's look at practical examples. If a makes a gift of his jewels to be, this can be done by delivery. On the other hand, if a gifts a piece of land worth Rs. 50 to be, registration is required. These examples illustrate the difference in legal procedures for movable and immovable property, emphasizing the importance of compliance with statutory requirements to ensure the validity of the gift. Property being gifted must exist at the time of the gift. A gift of future property is void, as the law requires certainty and clarity in the transfer. When a gift is made to several persons and one or more donees do not accept, the gift is void with respect to those who do not accept. This rule ensures that only those who willingly accept the gift benefit from it, maintaining the integrity of the transaction. Gift once given cannot be revoked at the mere will of the donor. The fundamental rule is that a resumable gift is not a gift at all. However, certain conditions allow for revocation. Conditional gifts, gifts made under coercion, fraud, undue influence, or misrepresentation may be revoked by the donor. The law protects transferees who take property for consideration and without notice from prejudice due to revocation. Conditional gifts are valid if the condition attached is not vague, illegal, immoral, opposed to public policy, or impossible to perform. For example, if a gifts a plot of land to B, reserving the right to take it back if B or his descendants die before A, the condition is valid. However, if the condition is immoral, such as gifting property to a concubine for continued relationship, the gift is void. The law distinguishes between valid and invalid conditions to uphold ethical standards. Consider the example where it gives Rs. 1 lakh to B, reserving the right to take Rs. 25,000 at his pleasure with B's consent. The gift is valid up to Rs. 75,000 only and void in respect of Rs. 25,000. This illustrates how partial revocation works, ensuring that only the unreserved portion of the gift remains valid. The law provides clarity in such cases to prevent misunderstandings and dispute. Gifts made under coercion, fraud, undue influence, or misrepresentation may be revoked by the donor. The law protects the donor from unfair practices and ensures that gifts are made voluntarily. In the case of Alcard versus Skinner, a gift executed under undue influence was challenged, but the claim was dismissed due to delay in suing. Timely action is essential to protect rights in such situations. Transferees who acquire property for consideration and without notice are protected against any prejudice resulting from revocation by the donor. This safeguard ensures that bona fide purchasers are not adversely affected by disputes between the original parties. The law prioritizes fairness and stability in property transactions, maintaining confidence in the legal system. Section 127 of the Transfer of Property Act deals with onerous gifts, which are transfers where some properties are burdened by obligations. The donee must accept the entire gift, including the burdens. If the gift is made in separate transactions, the donee may select and refuse those not beneficial. This concept ensures that the donee cannot cherry-pick only the advantageous parts of the gift, maintaining fairness in the transfer. For example, a gifts in one transaction 200 shares of X & Co., a prosperous company, and 100 shares of Y & Co., company in difficulties. Heavy calls are expected from Y & Co. The donee must take the entire gift, becoming an onerous donee. He cannot accept only the shares of X & Co. if the gift is made in separate transactions. The donee may refuse the burdensome parts. This rule prevents selective acceptance and ensures the integrity of the gift. A minor who receives an onerous gift may repudiate it after attaining majority. This provision protects minors from being burdened by obligations they may not fully understand or consent to. The law recognizes the vulnerability of minors and allows them to make informed decisions once they reach adulthood, ensuring fairness and justice. Donee is liable to the extent of the total gifted property in his hands. This means that the obligations attached to the gift must be fulfilled by the donee, ensuring that the burdens are not ignored. The law provides clarity on the extent of liability, preventing disputes and ensuring that the donee understands the responsibilities involved. Universal donee is a person who receives a gift of the entire property of the donor, including both movable and immovable assets. The universal donee is liable for all debts, dues, and liabilities of the donor at the time of the gift, but only to the extent of the property received. This concept ensures that the universal donee assumes both the rights and responsibilities associated with the property. Liability of the universal donee is limited to the property received. If a makes a gift of only movables to B is not a universal donee. The universal donee is not liable for debts and liabilities incurred by the donor after the gift is made. This rule protects the donee from unforeseen obligations and ensures that liability is clear and limited. Moving on to leases, Section 105 of the Transfer of Property Act defines a lease as the transfer of the right to enjoy immovable property for a certain time, in consideration of a price paid or promised. The consideration may be a fixed amount, a share of crops, or periodic payments. Leases can be oral or in writing, but if the lease is for 1 year or more, it must be in writing and registered. Leases for 1 year or more must be in writing and registered. Leases for lesser periods may be oral or in writing, with registration being optional. Delivery of possession is necessary in both cases. These requirements ensure proper documentation and legal recognition of lease agreements, protecting the interests of both lessor and lessee. Lease creates an interest in the property, granting exclusive possession to the lessee. In contrast, a license does not create any interest. It is merely permission to do an act that would otherwise be unlawful. A lease is assignable and not revocable, while a license is not transferable and is revocable. These distinctions are crucial for understanding the legal implications of each arrangement. One of the key differences between lease and license is exclusive possession. A lessee gets exclusive possession of the property while a licensee does not. This exclusiveness is a defining feature of a lease and is often used by courts to distinguish between the two. The lessee can bring an action for trespass, but a licensee cannot sue in his own name. A lease is assignable, meaning the lessee can transfer their interest to another party. A license, however, is not transferable. Additionally, a lease is not revocable while a license can be revoked at any time. These features impact the stability and security of the arrangement, making leases more suitable for long-term interests. According to the Transfer of Property Act, leases for 1 year or more must be registered. Licenses do not require registration. This distinction ensures that leases are properly documented and legally enforceable, while licenses remain informal and flexible. The law provides clear guidelines to prevent confusion and protect the interests of all parties. Leasehold creates a heritable interest, meaning it can be passed on to heirs. A license does not create such an interest and is determined by the death of the grantor or licensee. This difference affects the long-term value and security of the arrangement, making leases preferable for those seeking lasting rights. A lease that requires registration is not registered. The position was controversial due to various high court decisions. The Transfer of Property Act was amended in 1920 to clarify this. The Privy Council held that non-registration renders the lease void. However, the doctrine of part performance may be invoked to protect the lessee, allowing unregistered leases to be admitted in evidence to show possession under a lease. Section 108 of the Transfer of Property Act outlines the rights and liabilities of the lessor. The lessor must disclose any material or latent defects in the property, put the lessee in possession, and ensure quiet enjoyment of the property if the lessee pays rent. These duties protect the lessee and ensure transparency in the transaction. Lessee has several rights, including the right to accretions, the right to sublease, the right to fixtures, and the right to repairs. If the property benefits from accretions, the lessee is entitled to them, subject to laws relating to alluvion. The lessee can sublease unless prohibited by the lease deed, and is entitled to fixtures affixed to the land. A lease is voidable if the material part of the leased property is destroyed by fire, tempest, floods, violence, or enemy action, provided the lessee is not responsible for the destruction. The lessee may avoid the lease if they prefer. This provision protects the lessee from unforeseen disasters and ensures fairness in the arrangement. The lessee may make repairs if the lessor neglects to do so, after giving reasonable notice. The lessee can deduct the expenses from rent or recover them from the lessor. This right ensures that the property remains in good condition and that the lessee is not disadvantaged by the lessor's neglect. If the lessor neglects to make payments such as house tax, the lessee has the right to pay and get reimbursed from the lessor. This provision ensures that essential payments are made on time and that the lessee is not penalized for the lessor's negligence. The lessee has the right to free ingress and egress, meaning they can enter and exit the property freely. Upon termination of the lease, the lessee can carry away any crops grown during the lease. This right ensures the lessee's access and ability to benefit from their activities on the property. Lessee is bound to restore the property to the lessor in good condition as it was at the time of the lease, subject to normal wear and tear. The The lessee should not use the property for purposes other than those agreed upon, nor should they damage buildings or commit destructive acts. This duty maintains the value and integrity of the property. The lessee should not erect permanent structures on the property except for agricultural purposes. This restriction prevents unauthorized alterations and preserves the original character of the property. The law allows flexibility for agricultural improvements, recognizing their importance. The lessee is bound to pay the rent as agreed upon in the lease. Timely payment of rent is essential for maintaining the lease and ensuring the lessor's rights. The law enforces this duty to prevent disputes and protect the interests of both parties. Important cases such as Spencer's case and Kadiavini Devi versus Udava Kumar illustrate the application of lease laws. These cases provide guidance on interpreting rights and duties under lease agreements, helping parties understand their legal position and resolve disputes effectively. A lease is terminated by efflux of time when the fixed period expires. For example, a lease for 2 years ends automatically at the end of 2 years. This method provides certainty and clarity, allowing both parties to plan accordingly. A lease may be terminated on the happening of a specific event, such as the death of the lessee or the expiry of a set period. This method allows flexibility in lease arrangements, accommodating unique circumstances and needs. When the lessor and lessee become one, such as when the lessee buys the lease property, the lease is terminated by merger. The lessee must buy the entire interest in the property for this to occur. This method consolidates ownership and ends the lease arrangement. A lease is terminated by surrender, which involves the lessee yielding up the term to the lessor and delivering possession. Mutual agreement is essential for surrender, ensuring that both parties consent to ending the lease. This method provides flexibility and allows for negotiated termination. Implied surrender occurs when the lessor accepts a new lease with different terms during the continuance of the existing lease. This results in the implied surrender of the original lease, as seen in Gemini Mohan versus Devendra. The law recognizes this method to accommodate changing circumstances. Forfeiture terminates the lease when the lessee breaks an express condition, sets up title in a third person, or becomes insolvent. Notice by the lessor to quit is essential in these cases. Acceptance of rent by the lessor after notice amounts to waiver of forfeiture, maintaining fairness in the process. Notice to quit or terminate the lease must be given by the lessor to the lessee. If the lessor accepts rent after giving notice, it amounts to waiver of the notice. This rule ensures that both parties are aware of the termination and have the opportunity to respond. For example, if A, the lessor, gives B, the lessee, notice to quit and the period of notice expires, but accepts rents from B, the notice is waived. This practical scenario highlights the importance of actions and intentions in lease termination, ensuring that both parties understand their rights and obligations. Summary: the Transfer of Property Act provides clear guidelines for gifts and leases, outlining the requirements, rights, duties, and methods of termination. Understanding these concepts helps parties navigate property transactions with confidence and ensures legal compliance. Whether dealing with gifts, leases, or their revocation, the law aims to protect interests and promote fairness. Thank you for joining us on this comprehensive journey through property law essential.